Hello, my name is Leonard Lang. This is a follow-up video to my visit to CalRecycle in the month of December, the monthly meeting. I believe, as a report that came out, California has the worst legal environment of any state, and especially when it comes to regulation, which is why I'm involved in this process of uncovering problems within the process. Within the beverage container program, though, in 2000, a law was passed, and it changed the status of a program participant, certification, a licensee, if you will, and it no longer said that this was a right as guaranteed under to have a business as guaranteed under the U.S. Constitution, but now under California's Constitution, it's a privilege. And 2000 is also the year that, from the governor's website, the current assistant director came on board with the program. My question is, since that bill that I read had no support or no opposition, where did the language come from? Was that something instigated by the division, the program? I believe so. 2003, a law was passed to give away a lot of money, and that meant that the department had to adopt some regulations to give some of it away. And the one I got involved with was plastic, the market development payment. And the staff were talking over the proposals at the LA meeting, and they said if you do something, you get so much money. If you do something else with it afterwards, you get another amount of money. They said if you do both at once, or both within your own company, you still only get half. That's not what the law said. I challenged it. They looked somewhat shocked, but I'd been told by my mentor that often staff will go awry. They'll go off the rails and do what they want and not what the law wants. With that exposed, everybody looked over to an attorney over in the corner of the room, and he said he wasn't there to, or he didn't write the regulations proposed. He was just there to answer legal questions. Well, he also didn't make sure that the staff interpreted the law correctly. Now, 2010, a few things happened. CalRecycle was formed with the Waste Board and the Division of Recycling. State auditor issued a report saying that the program suffered from ineffective management. It was the first of two audits. LAO Director Mac Taylor said the use of budget bills was not a proper place to change the policy of this program. Division of Recycling did an enforcement surveillance watching cars come in from Reno, and they made a big report. I got a copy of it, I think somewhat by accident, but nonetheless it showed that they watched several hundred people come in from Reno, watched it go and be sold to recyclers, and never stepped in and did anything about it. Never protected the fund. That's their function, to protect the fund. They proved with the report, they had names, licenses, driver's licenses, everything to prove that these people would appear to be California residents and therefore eligible for the for payments. Also, Sacramento Bee did a report. The first 5 years of the e-waste program, over $30 million in claims had been denied. Now, 2013, changes to the program were, I believe, instigated by the department and put in a budget bill. Some of those changes conflicted with the goals of the program, which is indicative of poor management. Follow the goals, don't challenge the goals. From that passage, SB 96, they adopted onerous regulations for both certification and for load limits. Because of a problem within statute, those regulations, emergency regulations, are permitted to stand and never be adopted permanently, and department has not done that. Okay. That year also I spoke to Kip Lipper about problems. He arranged a meeting between the director and myself at his office. The director did not show, the assistant director did, and we didn't accomplish too much. So he requested another meeting, and we had that over at EPA. At that meeting, almost everybody was there except the director, but chief legal counsel, some attorneys, enforcement, certification, branch chiefs, a ton of people were there. I discussed the problems that I saw within the program. Following me, I had brought former director of Office of Administrative Law, and he spoke to them. He said that based on his interactions, the program had a cultural problem, and he spoke to that. He had also just filed a petition for use of underground regulation against the department, and they questioned him about that, and they settled on the fact that they should probably do a Form 280 or a Section 280, which is a confession, which they did. That confession and the contact person on that confession, signed by the director, was the now current assistant director. Now, over the years, I could see that pieces of that underground regulation were still being used in informal training. It hadn't stopped. In 2014, again, another budget bill making an onerous change and extending the statute of limitations on recyclers and processors 250%. You don't see what goes on in budget bills. I call it stealth legislation. Okay. Also, that year, because of the first budget bill, where they eliminated the ability for recyclers to purchase commingled, they found that they'd made a mistake. Their favorite recycler was now put out of business in using their machines. Machines can't tell whether things are CRV or not. So they passed special regulations in conflict with the law. And also that year the state auditor published the second report, and it said changes are needed for the program to be sustainable. It identified significant waste, significant excessive costs within enforcement for very little productivity, very little recovery. They also had a legal opinion in that report that the department's methods of denying payments to recyclers and processors were likely underground regulation. I supplied that information. Now, also, later on, that same underground regulation was used by the Attorney General's office in a criminal prosecution against a recycler. Based on a quirk of the Superior Court judge, the evidence that this was underground and therefore inadmissible was never allowed to be presented. I've called it the underground regulation from hell. 2015, because of the report in 2010, all that importation that the enforcement never stepped in and never prevented, what did they do? They didn't do anything for a year after they did the report, but then they started to go after the recyclers. They never in the interim told them not to buy from specific people or what to watch for. Never did anything. They held them responsible for being defrauded. Okay, so there's a hearing. They're going after a small recycle from Susanville for roughly $1 million. Judge Vorder, Office of Administrative Hearings, hears the case, and in her decision basically spanks the department and says that the public was not served. There were issues within that, credibility issues, and an attempt to deny exculpatory evidence, i.e. that report showing they had observed 200 plus vehicles. Okay. Also that year, the assistant director Ortiz left, and he and I had argued over the underground nature of that notice for some time. And he even said he checked with legal and that there was case law. And so when he left, I asked him, which attorney told you that? And he said, oh, they had left. Well, no attorneys had left. All right, In 2016, the governor hosts a gathering to talk about giving more power to regulate to CalRecycle that would take away or be relinquished by the legislature. I supplied a report showing how bad the track record of the department's regulating had been in the previous 3 years, and it never progressed. It's also the year that I found out late in the year, the recycler told me I had been blacklisted by CalRecycle, that she'd been told if she was found associating with me, it wouldn't go well for her, meaning she'd lose her licenses. Now in 2018, the attorney responsible for legal interpretations in this program for a long time becomes the assistant director. And then just a couple months ago, I find where a recycler in downtown LA has been visited by auditors and told that he shouldn't be buying from certain people, basically scavengers. This is downtown LA. And they provided him with a document proving their instructions were authorized. What did he get handed? He got handed that same damn notice from hell, the underground regulation from hell, which is still being used, which the current assistant director was supposed to ensure was not used anymore. He asserted that in his letter. What we've seen here, what I deal with, is a consistent denial of due process, denial of rule of law, and a failure to provide the protections to the regulated by the Administrative Procedures Act. We're running, all they do is emergency regulations, and not just in beverage containers. We've got it going on in e-waste, and anywhere the legislature has left a loophole in statute, it's probably being done by the department. Anyway, I'm going to expose as much of this as possible. People need to understand. I'm sure this program is going to be changed this year, and it needs the right changes. So I thank you, and stay tuned for more.